Did it twice? Hey, everybody. We're back. IMMPact Litigation. Myself, Aaron Hall, Greg Siska, and Jesse James Bless. Is that really your real middle name, Jesse James Bless? Because that would be cool if your parents did that to you. That would.
I wish it was, but it's no. It's I am a gunslinger. That's my nickname. But no, it's not. It's Matthew.
You must have been brutal in law school. I'm glad I didn't go to law school with you. You probably like right at the front. Hand up. I got this question.
No,
that's
I was the opposite.
Law school. We used to call those flamers in my law school. I don't know what they called them in other places.
My son's law school, they called them.
Hold on, you got it totally wrong. I was the kid praying that I graduated because I'm the first one in my family to actually go to college. So law school was like I didn't know.
As was I, my friend.
I am 3 generations of law students. The first one actually take the bar. And
there you go.
There you go.
I don't know which is worse.
Hey, it's great to be with everybody today. We're going to start off with I do want to mention that we will not be mentioning diversity lottery today. There's no news. There's no information. There's nothing. We will not hear anything until next year. So we're not going to answer questions about that.
No questions.
And congrats. I guess the DV 2024 lottery is now ended. So congrats to all those folks.
We will not be suing in that case.
No, I don't think so. I mean, I just kind of curious when you think about it. If by August they've only issued 20,000 diversity visas, I don't know.
Maybe.
It's a good question. So EB5, Jane litigation. So there's a couple of Jane cases. So Jane is what I'm handling. This is the one where we've gotten discovery from the government as order from the court. It is garbage discovery. It is just literally like, here's all the stuff we said publicly. And it's useless. So Matt and I are meeting this week. We're going to go over how we want to move this. Any motion for summary judgment is not due till January. I think we're going to probably going to ask the court for some additional discovery because what they presented is useless. The court did say, though, well, don't ask for additional discovery. Let the government go first on a motion for summary judgment, and then you could ask for discovery if you need it. So there we are. Now, our Jane case, this EB5 case, what's interesting about it is that there's really been no movement for our 526 plaintiffs. None. They just basically, I guess he pointed this out earlier in a private email chat. Hey, we're just processing cases like they could be used, which is garbage. And of course, if you're a 520, now our 526, this particular litigation is 526s with consular processing. If you are 526 in the United States, you can just file your adjustment, right? And then go individually there. The third EB5 case is actually the people who have approved EB5s, just couldn't get a consular appointment. And now every one of those plaintiffs has had a consular appointment, except for one. And it's because they got some documents missing and they're not responding with the required documents. So that case will likely be put on a back burner by the court. Our EB5 Jane case, the 526s, will be, I think we're going to continue litigating this and probably ask for more discovery. It's a slog, but it's going to be a slog anyway if you do nothing. So hopefully we can fix this problem for our plaintiffs. And then the last EB5 case is the 829s, many of which have been granted. So that's kind of where we are on the EB5 stuff. I do want to talk about, give the floor to Jesse to talk about Ukraine and our what are we going to call this? Our crusade? I don't know. The right thing? There must be a word for that. Crusade's a bad word for that, but yeah, never did the right thing. It's a kind of our quest. It's a quest, is what this is. It's a Quixote-like quest.
I think at this point, I mean, it's pretty safe to say that we've reached an agreement on the law and what the law means, which is the government has agreed and put it to the court. We agree that, these people should have had work incident to status and got it wrong, and we're going to settle. And so we've agreed to settle. We just haven't settled. And we have. And part of that is an outstanding issue about how they're going to refund the money they improperly charged the plaintiffs. And that's really the outstanding issue. That's what we're sitting here And I've tried to say, well, why don't you just let the people work and actually follow the law? Because, why not, right? It makes sense. And, it's just really frustrating because we don't really have a judge who's forcing the government to do the right thing at this point. So I think, and correct me if I'm wrong, team, I'm just going to, if we don't have an agreement, we're just going to have to cut off negotiations and just force the issue. I mean, I'm not going to just I'm not arguing or trying to negotiate against the clients.
We should also clarify. I mean, the government has yet to file a single piece of paper arguing against anything that we have in our complaint. They've been getting extension after extension, and we've been opposing the extensions. On there, we want the government to just wrap it up. But unfortunately, we have not, as you mentioned, we haven't had a judge that at this point is willing to force the issue.
Jesse, remind, when did we file this lawsuit?
July 26th, I think.
And Greg, how many months notice did we give the government we were filing this lawsuit?
Well, we told them like almost a good month ahead of time. We didn't we discovered this problem in June, and we let them know almost immediately that we had discovered this problem, and were told by somebody high up that they were looking into it, and then dead silence and nothing. And I'm pretty sure that if we hadn't filed the suit, they would still be sending memos back and forth across the agency to decide what to do rather than actually being forced to make a decision. Yeah. But it's,
the frustrating part of it is it's one of the rare lawsuits that we've done where nobody's fighting. It's just that they won't follow through. It seems like the even government counsel, I think they're being honest. I think they just have a very difficult client. We just can't get there, and so I think we're just going to have to force the court.
For people that are watching that, it's like we had discussions with them about separating this issue out and doing, giving people immediate relief while we work on the other issue. That's a choice that the government is making, not to move forward on this case at all, and not to provide relief until they're good and ready. We've told them that we are willing to have that discussion, be flexible. We're barely having a conversation. It's basically we say we're willing to have this discussion. We're willing to be flexible about it, at least that to get some interim relief. But we're not hearing anything back from the government that's productive at this point.
To state the obvious, I mean, what we're talking about here is, in the world of litigation, it's, another few weeks, another month. What's the big deal? But what we're talking about is people who've arrived here sometimes with nothing, with not much, fleeing a terrible situation. And the law says that they're authorized to work. And the agency has said up to now, no, you're not authorized to work. And you have to pay us to apply for work authorization. And it's going to take however many months, 10 months, 12 months, 14 months. And so these people are without the ability to support themselves and their families. So the urgency, I feel like, is just not being recognized.
Aaron, I think it's also worth noting that in this particular program, you had to get sponsorship from individuals, but a lot of the sponsors, for example, are just like small town congregations that are pooling their resources. So they're not just hurting the immigrants in these cases by not allowing them to work. They're hurting everyday Americans who are basically subsidizing and underwriting the support for these people who could easily support themselves. We have 3.7% unemployment in this country. These are people who want to work. There's plenty of jobs available to them. So, this is needlessly inflicting stress on them while the government, takes its time in making a decision on this. They could solve this problem today. They know they already know what they have to do. In fact, I'm sure they already, have it ready where they could just flip the switch on the website to make it possible for these people to work today. It's not very hard to do that. They know what they have to do. The other thing that's kind of nice about this situation, unlike H-4s and others, is everything they need to prove eligibility under the May statute is on that I-94. There's not subclasses and some people that are eligible and ineligible. All they have to do is prove when they came into the country after February 24th. That's on the I-94. They have to prove that they are Ukrainian, That's on the I-94. And they have to prove that they entered as humanitarian parole, and that's on the I-94. So there's nothing that they have to do other than update the website to say that if somebody presents an I-94 with that documentation, that is evidence of employment authorization. They could do that today.
Two things as a follow-up to that as we wrap this up. First, the truly tragic part about this is they've kept taking money.
Yeah.
They're still taking money for something that they acknowledge was illegal for them to do. Let's be clear. This is about the government violating the law. Just flat out. If you as a business owner take money from somebody you're not entitled to, you go to prison for things like that. I guess when the government does it, it's like, oh, maybe we'll get around to fix that one day.
It's a loan, Chuck. It's a loan.
Here's the other part, and I'll just end on this. Maybe I could understand the delay if Stephen Miller was still running the Immigration Service. I could see them dragging their feet, being jerks about stuff. It is unconscionable that this is the agency run by Joe Biden's administration. You should be embarrassed, man. You are literally sin vergüenza is what you are. You are sin vergüenzas. And I will leave it at that.
But make sure you vote if you're eligible. If you're a U.S. citizen. If you're not a U.S. citizen, please don't vote. But if you're
vote. All right. So we wanted to talk about a couple other pieces of litigation that are going on right now that we're starting up. And this is the one that I think have the most impact for the most people. And this is the continued onboarding of our 601A case. So if you are in the United States and you did not arrive in an orderly fashion, you did not have a visa when you came without a visa, you came illegally, and you are married to a U.S. citizen, you have a spouse who's a resident, you have a parent who's a resident or citizen, and you are in the process of getting your green card, whether through your parent, whether through your spouse, or even through your employment, you have to leave the United States to do that. So if you come in illegally, you can't get a green card here. You have to go home. But the moment you leave, you can't come back for 10 years. All right. That's why nobody leaves. Why don't people just leave and fix it? Because they can't. They get the 10-year bar. The provisional waiver was created under the Obama administration as a way to minimize the disruption in lives by getting an advance forgiveness. So before you leave, still got to go, but before you leave, you get forgiven based upon showing extreme hardship to a U.S. citizen, parent, or spouse. This is called the 601A process. And starting in 2013, when Obama initiated this program, up really until, if I get this right, 2019, these were taking 6 months, 4 months, 8 months, 6 months, something like that. They're very minimal amount of time. And then, for whatever reason, since maybe it's even through 2020, since Joe Biden's been president, they basically stopped working on these cases. And now, if you go to the website and you look at Nebraska, who does basically all these cases, they're telling people it's 31 months to get approved. That's, first of all, that's almost a third of the time you could stay out of the country, but it's insane. There's no legitimate reason this is the case. So we're onboarding a lawsuit for the delays. The date will be changed on the website. Don't worry about that. But if you go to IMMPact Litigation, you will see the website for onboarding. And this is something that I have a lot of 601A waivers. I'm very passionate about this. We do a lot of family-based immigration work. We have a lot of mostly Latinos that are kind of stuck with this particular problem. And this is something that we can fix. Because you don't go, Jesse, you're from a government guy. Do you get to go from processing things in 6 months to 31 months and not get called out on that? I don't think you do.
Yeah, I think it's going to be tough to explain, and I don't know if the government, the Ninth Circuit, we just issued a decision last week. It's a little different, but in this, special immigrant juvenile context where there's actually a statutory deadline, and they fought that all the way up on appeal and had to get slapped down. There's a statutory deadline. We don't have that here, but in the same type of context where these are really supposed to be prioritized so that people can avoid the threat of deportation and go abroad to consular process because they have a qualifying relationship and someone who's going to suffer extreme hardship. So I don't understand. And in fact, part of the litigation is going to be, pulling the, the road back and seeing what excuse is there for the it's like an 800% increase, right? I mean,
it's insane.
Justify that.
It's insane. It's just, and the funny part is they publish their own historical processing times. They're basically calling themselves out.
Well, and you know what they're going to say too. They're going to say, well, why don't they just go abroad and they can just apply there? Like I'm just waiting for that. I'm saying it because it's you hear it and you're like, that's insane. But like they don't vet it that way. They'll say, well, yeah, there's an alternative option. They can just go abroad
and wait for the 601 to be approved.
Correct.
Which, by the way, is only taking 1 year, but then you got to have 2 households apart from. No big deal. I'm sure you'll be fine.
Yeah, and just live away from your children. Yeah, that's fine, right? That's just
the answer on that is that's the way it used to be, and they created domestic processing of this to fix a problem. So why if this was not necessary? I mean, if it was just as well to be able to process abroad, why did they institute domestic processing in the first place? The problem. I mean,
what they should do? They should just go fully forward and actually let these people adjust and apply with a 601A with a concurrent 485. And this is getting super technical, but like, don't ever let me in the room with Congress because I would just say like that's the easiest way to do it. Just let them do it and just say, we'll treat an approved provisional waiver as an admission. Why don't they just do it? They just do that. Why not?
Because they would take money out of their hands.
Dude, USCIS. USCIS would actually make more money because they get to do the adjustment instead of state getting to do consular processing.
Well, consular processing. Yeah, it's true. I mean, they would make more money, but that would require more bodies. Bodies.
We get it's like the 245I, right? How much money did they make off of that program?
Billion, still making money off of that program still today. Yeah. All right. The next thing I want to talk about is our litigation on advanced paroles and EAD delays. Now, Aaron led us in our EAD litigation, the Kang case, where all of our plaintiffs got their EADs relatively quickly after we filed, and the court declined to allow a class to proceed. Aaron, I still don't understand why not. I just still don't.
Well, there was one little change that happened after we filed our suit that the court kind of hung its hat on, and that was that they instituted 540-day automatic extensions rather than 180 days. And so they said, well, you can't really be sure these harms are going to be repeated because they have these longer auto extensions. Well, that doesn't take into account the fact that the initial applications are still taking that long.
Yeah, still taking that long, right? Yeah. If you even get it, I mean, I since we do a number of
family cases, categories that aren't eligible for that
exactly
40 days for extensions.
And this goes to the advanced parole, which basically they've stopped issuing advanced paroles in adjustment of status cases. The only advanced paroles I'm seeing are DACA recipients. So advanced paroles in adjustment cases, they basically have stopped issuing. The fastest server center is 7 months, but California is 12 and a half. And we are frequently getting actual green cards for people faster than the advanced paroles. It's never coming. Which means they're taking money for it.
Unless you're
not doing the work.
In which case you're not getting that adjustment.
So what are these things? Advanced parole and EAD. They're interim benefits, right? They're designed to kind of tide people over while they're waiting for the main benefit. And to Chuck's point, what is the point of these interim benefits if they take longer than the principal application itself? The agency's just way out of whack.
There's also there's no substantive analysis that goes in on either the EAD. All they do in those cases is determine if you have an underlying application in the correct category, which can totally be automated, or the receipt itself. They can just put it on the receipt for the adjustment application that receipt is valid for employment authorization and for advanced parole, because at least in the case of employment authorization, advanced parole, all they're doing in the computer is checking to see that you have an underlying adjustment application. That's a manual process that they go through. It takes 12 minutes, I know, in EADs. It's probably even less time for advanced parole. In theory, you're supposed to show you have a bona fide reason for travel. That was maybe, what, 25 years ago, Chuck, that they moved to that?
Yeah.
Have you ever seen a denial on that based on not having a bona fide reason?
Not for that reason, but there is one incident. I'll give this to the government. There was a time long ago when I didn't have gray hair where some unethical folks would file an I-485 adjustment of status for someone who was not eligible because they didn't have a lawful entry, but they would include an advanced parole, and they would get the advanced parole, send their client to the country, client would come back. Now the client has a lawful entry, withdraw the adjustment and refile it. That is fraud, in my opinion.
Right.
And
that's the
immigration
thing about it is that if you're depending on somebody to commit a crime in order to be able to take advantage of the benefit, it seems to me that that's not a that's not a reason.
This is something that immigration should have automatic. If you don't have a lawful entry, if you're not lawfully here, you shouldn't get an advanced parole. Right. And unfortunately, that trend is coming back because I've seen individuals do this recently. And clearly, if they're not adjudicating advanced paroles and looking at least at this issue, which is an easy tell, box on the form, when did you last enter, manner of entry. If it doesn't say my visa, why are they getting an advanced parole? Mm-hmm. You know, so this is, so they clearly, maybe they are automating it the wrong way. Who knows? But in order to avoid fraud, you have, but that's again, a quick check, right, Greg? Look and put a little coding in the system. Hey, if they don't have this, you know, no.
All they need to do, though, I mean, again, when the information is entered for the adjustment application in the system and it generates a receipt on there, everything that they need to know has just been determined.
I agree.
When they issue that, so there's no reason they couldn't do the receipts for both employment authorization and advanced parole, other than it's a jobs program for USCIS.
Well, one of the things for our cases, though, that's important for the audience or whoever watches this to recognize is that, you know, they've started bifurcating the issuance of EADs and advanced parole so that you can sign up for both and you get like kind of a discount. But I mean, it's important to recognize that this is a new, and you cannot make up the ridiculousness of it. Like that the way that they came up with in their genius, which to solve this issue, which is a known at this point on the delays, is, well, we'll just issue EADs and we won't do AP. And I can't even understand how you can get to that conclusion. But it's a reason why we have two separate cases now. And if you are a victim of both delays, you can actually sign up for each case and get a discount there, because we do know there are people who can't even get one or the other. But it's just it's like Abbott. You know, remember the old guys, Abbott and Costello? I used to watch. I mean, it's like we can't even. You know, it's if it wasn't so tragic, I mean, it'd be.
Well, this is management through the Peter principle, is what this is. But Jesse, you mentioned there's a discount. There's no discount. If you're filing an adjustment of status application, you're paying $12.25 for the adjustment.
Oh. No, I meant for our case to sign up with us. If you're suffering from both delays on interim benefits.
Then for us, we're discounting that. So
no, they're not cutting you a break.
And what they're doing by never issuing the advanced parole, they're making $575. They never had to do the work. How that is different, by the way, than demanding money for an EAD for Ukrainians, I don't know, because it also seems like theft to me as well. But so that we have that. The next thing, just briefly, we are still onboarding for our visa fee CVIS litigation. I'm going to just change the banner here. And Greg, do you just want to do a quick summary of what this is? We haven't really spent a lot of time on.
Yeah, we're going to. No, it's not a CELO. We're going to get to this, but it's this is a case that is. It's dealing with basically, again, people who paid money, maybe not as much money as as others for some of our cases, but nevertheless paid money for benefits that were not provided. In this case, we're talking about two different agencies for people that were seeking visas to enter the United States. You have people who paid visa application fees and didn't get appointments, or as the State Department has this crazy policy that if they do, it doesn't matter who's the cause of the delay, and most of the time they were the cause of delay. If it goes more than a year without your getting an appointment, they just charge you again for it, and they don't apply the fee from previously. So they're charging those visa application fees. Also for Fs and Js, if you were seeking visas in those categories, you also paid a CVIS fee to get you, which was a preliminary fee you had to pay in order to be able to even apply for a visa. They were doing that even though ICE was charging the CVIS fee. Even in cases where people were not being permitted to have the visa interview at all by virtue of various visa bans that were in place that were found to be illegal, and some of those were from our litigation. But they were nevertheless charging those fees as if nothing was going on. So we are going to be seeking to force both ICE and the State Department to refund fees for people who filed for applications and had delays such that there was no the programs that they were coming over for were over, such as summer work travel for the J1s. And if they delayed your appointment from May to say October, that became that basically became worthless to you as far as filing that, because you missed the whole program. And then for ICE, for the F and the J CVIS fees. So that's what that's about. It's about getting people refunded fees, and it's also about sending a message to those agencies that if you take money from people, you have to deliver a service. You can't just take money like it's you're entitled to it.
Now, Greg, I would note that there was no fee to us for you enrolling in this lawsuit.
That's right. So we're doing it on a contingency fee basis.
This is free to you.
I have to admit, I am, just a litigator, right? I don't do the consular work or the petition work. One of the things that's been I've learned is that they charge you a non-immigrant visa fee for an appointment to look at the calendar to see if an appointment's available. But if an appointment's not available, they keep your money. But some consulates, they'll have it for 2024, 25, but you can't, if you're on an F or a J, you pay the fee and then you have to just go search at another consulate for an interview. But they keep that fee for you to, so it's you have to pay to see the calendar. And then if the calendar's filled, it's oh, guess what? Heads I win, tails you lose. That to me that can't be right. I that's, as the litigator in me is I can win that one. I don't understand.
It's a Trump level scam is what it is. I mean,
scam is the correct way to put it.
Yeah.
And they will tell you, oh, you have the right to request a refund, except it's impossible to find any information on how to do that. And there's no evidence that they've been doing that in any of these cases.
Yeah.
It's unbelievable.
So if you're interested in that, it costs you nothing. Get some of your money back from the government. Sign up. It's ongoing. Sign up. And our last is our round 3. Basted. It's not basted. It's not basted.
Is it like a chicken?
Let's try something different here. The employment. Still basted. I need to edit that. Let's go on.
Thanksgiving on the mind.
Thank you, Chuck.
Misuse policy here. So this litigation is very different from use the damn visas, which we won. They used all the visas. Now, all of our plaintiffs didn't get visas, but a lot of them did. I think it was ended up 70% did. And the rest, they just, they retrogressed. But everybody should have gotten a visa for 2 reasons. One, they misallocated visas. They just randomly assigned, hey, this guy's got an adjustment. Ignore the priority date. Doesn't matter. Just, oh, he filed last week. It's okay. Don't worry about the guy that filed 5 years ago. You don't need to worry about that guy. He doesn't, his file's somewhere else. You don't care. That's legally wrong. I mean, there's a statute that says they are issued by priority date order, period, end of story. Second, there is a policy determination that USCIS has recently published that says, hey, where numbers flow over, they are subject to the categorization of 40, 40, 40, 20, 20, and they are subject to the 7%. Neither one of those is legally correct. They're both incorrect legal interpretations. So anybody want to add on that? We want to bring the suit. We have some plaintiffs. We need more plaintiffs to effectively bring the suit. Jesse.
I would just say, like, so this is not you don't have to be from a backlog country to join this. No. You don't have to be, we're not, this is really about making sure that when you apply for an immigrant visa, an employment-based immigrant visa, that you actually are treated and considered in the appropriate way. And so, because what they're doing is affecting every category, and whether you're current or not, that changes every month. Theoretically, it doesn't have to, but it does. And so, if you're out there right now and you have applied or for an immigrant visa and you're pending, you should take a look at the lawsuit, because really you're not going to be considered lawfully and in the lawful way that the statute's written, as they're currently doing operations right now. They're not following the law, and it could affect you, and it probably will, no matter what.
I'm trying to figure out why they did this. I mean, what they came up with was a convoluted.
No, I know why they did it, Chuck.
Why'd they do it, Greg? I don't get it.
They did it because it wasn't all nefarious, as far as they wanted to get to that number and use up all the visas. However, of course, they could have what they did afterwards, as far as the rollover, is an issue, but they went for the low-hanging fruit. So they decided, we're going to ignore the law, and we are going to take cases that were filed much, much later for a couple of reasons. One is that those cases don't have to contact people to ask for a new medical exam. The medical exams that were submitted with those adjustment applications that came later on were unexpired. They could use those. They also didn't have to deal with RFE responses or anything like that, as far as that goes. They were just easier to approve quickly, people that filed later. That doesn't comply with the statute. It's also unfair to people who've been waiting, that filed in 2020 and got passed up by somebody who filed 2 years later. But that is that I'm fairly certain is the reason why they pulled these cases out of order and did it that way. Then there's the question of what how they could remedy it. They could remedy it just by interpreting the law the way it's possible, and letting those visas be allocated for Indians. Nobody, they could, you can make the argument that they should have to go to rest of world, which they're doing. But then the question is, like, why? Why would you, take that argument and say that all these people who have haven't been waiting at all, that should be allocated when there's some room for interpretation, instead of the group that's suffering the most? And they have the authority to do that, and the statute reads correct that they could do that. So that is but that's a separate question. Why they took people out of order, I think that's fairly clear.
We understand what they did. It's just that, what are they doing to make sure it doesn't happen again? Because we all know it's going to happen again, right?
I'm pretty sure absolutely nothing. Just like the H-1B visa lottery, which I saw in the question, somebody asked about that. What are they doing to prevent that whole fiasco from happening again? Absolutely nothing. So,
well, actually, there's one thing. Apparently, they are at least investigating one company who filed multiple applications through.
Yeah, but that's not that wasn't the clever way to scam us that we have seen, which is that you don't have to have one company that's doing it. All you have to do is have some middleman that finds lots of companies, and those companies might not even be scamming themselves. They may have legitimate jobs there. It's just that the H-1B applicant and the middleman that are finding these opportunities have found a way to basically improve your chances, 1,000% or more.
Well, at this point, we have the upcoming lottery, Greg. Ash they got a great question in this regard. Why wouldn't you try to find 40 different employers to file for you? You'd have to be stupid not to do that at this point.
That is absolutely what they have incentivized.
Yeah, absolutely.
By not putting an end to this, by fighting us on this litigation. That's the message that they sent out.
I hope a million people.
You're a fool. Of course, basically, is the message that USCIS is sending out if you don't do that.
I mean, you'd have to be a fool not to find a whole bunch of different employers to sponsor you.
Yeah, thank you. Good job, USCIS.
Wrong things.
Yeah, I mean, it's sort of a side joke. We're going to probably see 1 million applications coming in this year.
Well, I think there's going to be at least 750.
It's going to be almost entirely, the lottery is going to be almost entirely won by people that are not in the United States that are applying for IT professional jobs. And if you're a doctor or you're an engineer in the US or US grad, it's like, sorry, the USCIS has said that that's no longer a priority.
And the thing is, this is such an easily fixable problem. It's so easily fixable. Make the
one algorithm fixed. Period. All they have to do, they don't have to change anything. They don't even have to change their rules. They just change the algorithm so that one person gets one shot. That's all they can. That is not a hard fix. In fact, the irony is that most of these people that they are scamming the system could easily fix this problem for USCIS if they tap them to do that. They should say, we're going to give one person the visa that can fix this algorithm for us, and then you don't have to go through the lottery.
Well, if they need help with that algorithm, they should just call the Department of State, who runs this algorithm every year for the lottery. So it's just. They just copy it.
It's very easy to fix this problem with USCIS wants. I have no idea why they don't.
Here's a DV question. I'm only going to answer this because it goes to what is happening today in America. It is election day in the United States. Yeah. Even though 45 million Americans voted before today on early voting.
Feel good. Feeling good.
I secured my vote, whatever the hell that means. Secured my vote, whatever that means. So it's election day in America. Does the outcomes, first of all, most people don't understand. So our election is today. We won't know the results of many races for a week or two. In the case of California, it could be a month and a half.
The short answer on this is no, though.
No, it's no. It has no income on the cases. But these positions, and there's all different levels of elections from a mayor of a small town up to the Senate. But none of those people, when they win, take office immediately. They don't take office till January. So there's a time coming up here, Greg, called the lame duck session.
Yeah.
Is there any chance for anything positive on immigration coming out of the lame duck session?
Yeah. I mean, I think that I think the Afghan Adjustment Act, which is a lot of people, we don't talk about that one here, but that's a lot of people. That's about 80,000 people. There seems to be some bipartisan support for that. And there is discussion about that one being one where the votes are there during a lame duck. We could see some healthcare immigration legislation, including one that the Healthcare Workforce Resilience Act would actually take about 80,000 people out of the green card line, mostly Indians. So that could actually have a fairly significant impact on our plaintiffs, in a positive way. If that legislation happened, obviously it's great for healthcare in the U.S. That has right now 14 Republican co-sponsors for the Senate bill, which means that they don't have to worry about filibusters if they decide to bring that up. So there are these small bills. Some people are saying that the DREAM Act, maybe, I doubt it, but you never know. On there, what they if they want, but that I would say that the two that I would probably give the most chances to are a healthcare bill and the Afghan bill. Other than that, I wouldn't expect much. Now, when they come back, there is a lot of different things that could happen depending on what happens today on there, and if it's a red mirage. And the Democrats managed to hang on in the House, which, the early voting numbers look pretty good for the Democrats at this point. You don't know on there, but if they manage to hang on to the House, the Senate actually is another one. Look, if they can hang on to the House, that probably means that they will comfortably hang on to the Senate, just because these same and they need to flip 2 seats. In the Senate. The Democrats have 52 seats in the Senate, and they can hang on to the House. Get ready. There's a lot of stuff that's going to happen.
A lot of stuff that can get done
in January. I think the odds are not great, but we'll see in a few hours what that's looking like. But even if it doesn't, then I think what we're going to probably see is what we've seen for for years, which is a president that that can stop bad things from happening. And even if both houses flip and become Republican, that's a problem for the judiciary because we're not going to see any judges get appointed for 2 years on there. They will probably block every one of them. We're going to have a lot of empty seats. That means our litigation in a lot of cases, it's going to take longer to get decisions. It's going to be a lot of things for the long run if that happens. But I think probably what we would see is more aggressive use of executive actions, which is what's happened in the past when there's but we're already seeing that to some extent. But I would expect that there will be more and more of that, which means there'll be more and more litigation from the anti-immigrants that are basically trying to sue to stop the administration from doing things that might be considered pro-immigration. So it'll be a mess.
One good thing that could happen, the executive has control over, executive being the president, is he could affect change by telling his executive agencies how they litigate and not defend. Our Ukrainian case is maybe a good example.
Prime example.
Diversity visa case on appeal is another one. But like, if you wanted to actually make an impact and didn't have congressional support or even support to, pack the court or whatever, he's got some pretty, he could call off the dogs in a lot of these cases and actually start listening to us like the director of USCIS said she would.
No. I actually have a prediction that will be if the Democrats, if they lose both houses and there's no prospects for legalization or DREAM Act or anything like that we're going to see much more robust use of the temporary protected status program.
I agree. I think you can get 50 countries.
They've already started really accelerating the use of that. I mean, we just saw Ethiopia a couple of days ago, and we've seen a bunch of new countries added. There's a lot of reason. It's the reason why I think it's TPS versus DACA, deferred action or parole, is the statute is designed for groups, not this case by case decisions, which is what they've been attacking, these other benefits on. And it's really, really broad as far as what the president can do with TPS. It's basically it's almost pure discretion where Congress and the courts have very little to say when the president says that makes the decision that there is that there's a safety risk, and it's not just war, civil wars and disasters. It says that there's any risk to safety. In the statute, the president could use that in theory for a very high percentage of the DACA population. He could use it for the population that was supposed to be getting DAPA. I mean, basically, you can just say it's a climate emergency in Central America and let everybody that's in the country from those, from south of the border, in theory, come in. So that's something I'm expecting to see if there's bad news today, election-wise.
Greg, I would believe that if this administration was not run by Susan Rice, but she still runs this administration.
You know what? The Obama administration had a lot. They started out, not helpful at all, and then they changed a lot in that administration, especially as it was getting closer to the 2012.
Because Rahm Emanuel left.
Well, but they also, I think, realized that they needed to do it for re-election. And if Biden is going to run for re-election, I think that especially if the Latino numbers are bad today, I would expect to see him do some more in that space.
Yeah, I agree. All right, just EAD litigation, next steps for new plaintiffs. We're reopening this timeline.
And so we're going to have to. I mean, it's just be candid. We have not been promoting this litigation because we've had other issues that have been that have been distracting us. But we need to have a bigger number of plaintiffs. But I think we will get there once we're able to focus on building that up.
There you go. Let's see. That's about everything else is kind of lottery related, and I'm not going to really talk about the lottery today.
Lottery questions today.
Yeah, a lot of lottery questions, even though we're talking about a lottery. So hey, go out and vote. I think we've all voted at this point. Probably guess where we sent our votes in this election.
No competitive races in Tennessee. It's the way.
I'm going to tell you why we vote. We vote because we believe in America.
That's right.
We believe
Make
in
it a
America.
habit. You vote just because you're an American. I agree.
We believe, and we believe in what America stands for and can stand for. We have as immigration lawyers, we have a very unique perspective that many of our friends and colleagues simply don't have, in that we see the promise and dream of America every single day when we meet with our clients.
Yeah.
We talk to them. We see it in action. We see dreams come true. We see lives change.
By the way, that is the one positive for this administration, is that they have naturalized a lot of people.
They have.
They came in. So there are a lot of new voters that are casting their first votes today.
Yeah.
Because they naturalized in the last 2 years. So that's
Stephanie. Hi, Stephanie.
So that is so hopefully, well, I know we have some of those clients. I guess you guys probably do too.
We do.
It's really nice when that they've been able to do that. And that is the one positive you can say about the Biden administration when it comes to immigration, is they have got they have got good numbers on naturalizations.
All right, we'll see everybody next week.
Wow.
Let's end the broadcast here.